All right.
Judge, we're coming before you today just to give you an updated status on Mr. Staton, where he is with his probation and all of the evaluations that were complete. We completed the felony drug court referral for evaluation. He did not meet the criteria for that, so he was rejected. We did a TAP evaluation. The TAP evaluation recommends for him to be evaluated for the MIC caseload, dual diagnosis outpatient treatment, monthly UAs, and documented sober support meetings. He was evaluated for the mental health court with Judge Renhel, and at the time of his evaluation, Mr. Seton told them that he was not willing to participate in the program. His original conditions indicate if he was to be accepted, that a motion for new trial could be done, and then we go forth with that. So at this point, I've spoken with him. He indicates that he has the desire to move forward with the 2 years of deferred adjudication that was originally played out.
All right. So he's going to remain in custody for. Do we need to do that evaluation for dual diagnosis?
Well, the dual diagnosis is an outpatient program, Judge. It is not an evaluation. It's just like intensive outpatient or supportive outpatient.
All right. And is that going to be enough for him? Because obviously he has the mental health issues.
If we go ahead and place him on the MIC caseload, Judge, I think we can help him.
And has he been evaluated for that? And does he meet the criteria for the MIC caseload?
He has not been evaluated for the MIC caseload just yet.
All right. So he'll remain in custody for a MIC evaluation.
Okay, Judge.
All right. Christian Dunbar. Who's the attorney for Christian Dunbar? Yes.
You are a sharp, witty, and energetic commentator for YouTube-style legal and true crime breakdown videos. Your role is to enhance a courtroom or narrative script by adding insightful, entertaining commentary that helps the audience better understand what is happening while keeping the original dialogue fully intact.
There you go. Oh, it's already up here?
Way ahead of you, Joe.
You all are. Thank you.
Thank you, Judge. May we be excused?
Yes.
Thank you. Judge, can we approach on the trial?
Yes.
Okay.
Okay.
It's great for that.
Yes.
The jury's in the hallway, Judge.
Oh, they're coming back at 1:30.
Coming back along,
Yes.
so we can tell our people
Yes.
we're good till 1:30.
Can I
Yes.
just tell her about the indictment?
Sure.
So just to make the court aware, Judge, we are waiving some of the paragraphs in the
Okay.
indictment. And so I've talked to the clerks about how we do that with Odyssey, and the clerks have taken the indictment up to Elena to figure out how we do that. So just wanted to make you aware that we're kind of working on, we're waiving some of the counts and some of the paragraphs. And I think there's computer things that we need to do, or the clerks need to do to make that happen.
Okay. And then when you say you can let your people go, do you have witnesses here today?
I've got family here, so
Oh, okay. Yes. 1:30.
they want to watch.
Okay, sure.
Okay.
All right. Thank you.
Thanks, Judge.
You're welcome. Alboy Todd. Who's here on Alboy Todd? Thank you. Where's your client? Come down, please. All right, where are we on discovery?
I think the state's provided everything. We were notified if anything's missing.
Yes, Judge, I don't believe we're missing anything. We did receive an offer today. So if we could just get one more sitting to review this discovery with Mr. Alvoy, so that Monica can go show him stuff at the jail.
Okay, how old are you, sir?
43.
All right, so what I'm going to do, I'm going to set this for a plea deadline date, and we can come back either June 24th or June 25th.
Sorry.
Hmm?
Completely different matter.
Okay.
Discuss in a minute.
Is there any way? Yes, if we could do the 24th.
All right. So, Mr. Todd, we're going to come back on June 24th. On that day, you need to let the court know whether or not you've reached an agreement. Do you understand? Do you have any questions about anything? All right. We'll see you back then.
Thank you, Judge.
All right. You're welcome. Yes.
Have a good.
Commissioner, can I just?
Sorry.
Yes.
What time are we going to do?
1:30.
Sure, thanks.
Sure. Are y'all ready on Robert Uridalis?
No,
All right.
still talking, Judge.
All right. Thank you. Michael Johnson.
We're ready to announce, Judge.
All right. Thank you.
Johnson?
I have this court date as,
Oh. Yeah, gotcha. I'm sorry. Yeah, that makes sense.
all right.
I will provide a verbatim script that includes timestamps. You must not change or write to paraphrase or alter any part of the original script. Your only task is to add commentary voiceovers at carefully chosen moments without disrupting the original flow of dialogue or events.
Actually have this set for July 11th, but okay, we're here now.
Yeah, let's do it.
All right. So where are we on discovery?
Judge, like you said, it's a Monday on a Tuesday.
There we go.
As far as discovery goes, Judge, I think the state has turned over everything they have in their possession. I need to try and, I guess, subpoena something from ICS, Calling Solutions. My understanding is their mail goes through them now as well.
Okay.
If we could, I guess, set for a plea bargain deadline, Judge. We got
Yes.
an offer today. We've discussed that. And of course, I'd like to run down that additional information.
All right. I actually have you set for July 11th. Do you want to keep that date or do you need a different date?
That should work, Judge.
All right. So we'll come back on July 11th.
And is that for a plea bargain?
Yes, that'll be your plea deadline date.
Okay. Thank you, Judge.
All right. Is there anything else that's needed?
Nothing further at this time, Your Honor.
All right. Thank you. Oh, and I know that all the attorneys have decided to rush the 187th close to 12, but guess what? We're recessing at 12. So who's not done? Guess what? You're coming back on the 13th.
Not today.
No. All right. Are we ready on Uridalis?
Yes.
All right. Court is calling 2019 CR 4223, State of Texas versus Robert Uridalis. Can I have parties announced for the record for the state
Jason Gary, headliner.
defense?
Doug Campbell, ready?
And are you Robert Uridalis?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Robert Uridalis who was placed on deferred adjudication in 2019 CR 4223 for the offense of credit debit card abuse on May 17, 2019 for a period of 2 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor, I violated condition number 1 on or about the 16th day of April 2021 in Bear County, Texas. The defendant, Robert Uridalis, committed the offense of driving while intoxicated in violation of condition number 1.
How do you plead to that? True or not true?
True.
We'll waive the remaining violated conditions, Your Honor.
Any objections?
No.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That is to adjudicate guilt, revoke the individual office community supervision, and sentence him to 290 days in the state jail facility. And the defendant has agreed to plead in a misdemeanor for the DWI.
All right. And what is the cause number for the DWI?
659-312.
All right. Is that the agreement?
It is.
Mr. Uridalis, are you asking the court to follow that agreement?
You must insert exactly 5 to 6 commentary voiceovers no more and no less. Each commentary must be placed either before or after a specific timestamp. Never in the middle of dialogue. The original script must remain untouched in every way.
Are you waiving your right to appeal?
Yes.
All right, then the court will follow your agreement. The court will find you guilty, not grant you community supervision. The court will sentence you to 290 days in the state jail facility, give you credit for any time served, and this will run concurrent with County Court Cause number 659312. Probation, was there any restitution? All right, has that been paid? And is that to Stefania Balderas? All right, and the court is going to order the $800 restitution. Stefania Balderas. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that? Yes.
Judge, I was just reminded, when I did my calculation, it had 182 days for state ISF. We'd ask that be applied to this sentence. So,
All right, the court will give credit for any time served and inpatient treatment that was successfully completed. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Make sure you do better in life. Otherwise, you're going to keep coming back to court. You understand?
Yes, Your Honor.
And with regards to your judgment satisfied, sometimes the state jail facility will see that it's a judgment satisfied and they won't pick you up. But sometimes they will pick you up for processing. All right, do you understand?
Yes, Your Honor.
All right, Deputy Laura, the people in the box whose attorneys have not appeared and they're not ready, they're going to be called back for the 13th. Court is calling 2024 CR 4115, State of Texas versus Lorraine Nicole Farias. Could I have the parties announced for the record, please?
Jason Garrett, for the state, Your Honor. Ray Lopez for the defense, Your Honor.
And are you Lorraine Farias?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications in this case? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Any objections?
No, Your Honor.
Did you review the document entitled Court Admonishments with your attorney? Did you understand it?
Yes.
The charge is theft under $2,500 enhanced. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a
The commentary style should be sharp, engaging, and high energy, similar to popular YouTube legal analysis and courtroom commentary channels. Use hooks, dramatic emphasis, clear explanations, and light humor where appropriate to keep viewers engaged and improve audience retention.
right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Farias, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, 16 months in the state jail facility, no applications, State will take in consideration 727020. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Your Honor.
To the offense, how do you plead?
A no contest.
State any evidence.
Yes. No objection, Your Honor.
All right, state, you may be excused. Did you review the document entitled Wavering Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor. We just asked the court to follow the plea bargain agreement.
Court is going to sentence you to 16 months in the state jail facility, give you credit for any time served. Take in consideration 727020. There's to be no contact with Richard Ramirez and no contact with Coles. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
I'm 39.
Stop stealing.
Yes, ma'am.
You know what? Is a day in custody worth a pair of Nikes? You act as though it is because you keep doing this. Stop.
Yes,
Things are just things. If you want things, go get a job, pay for it.
Yes,
And if you think it's too expensive, then that means that you don't need it. All right, good luck to you.
ma'am.
Oh, no problem. So I've read what's been given to the court. I've read the violation report. I've read the affidavit of non-prosecution. So here's the thing. I'm going to want the complainant in here. So y'all have the complainant in here. And based upon what's on in the affidavit of non-prosecution, she's going to need an attorney. I personally have never seen where you had a complainant who says something didn't happen on the family violence side. I've never had or seen the state bring criminal charges. However, she is subject potentially to criminal charges if a false police report were filed. So we're going to reset this. And it's going to be reset soon because I'm assuming that she's cooperative with defense counsel, hence the affidavit of non-prosecution. So we're going to recall this and the court will hear it, and she'll need to be here, and we'll make sure that if she can't afford an attorney will be appointed to represent her. All right. So we're going to come back on.
Across the commentary, voiceovers include a balanced mix of legal or procedural clarifications, reactions to emotional or dramatic moments, questions that encourage audience participation, and short summaries or transitions that help the story flow smoothly.
June 24th for the court to hear this violation.
And just so, I guess the state will be responsible for bringing the witness if they're trying to pursue the violation report in the case.
We will not be bringing her in. I wouldn't want to subject anyone to criminal prosecution.
No, that's why she's going to have an attorney appointed to her. And if nobody's going to bring her in, I'm assuming that she's the person who has this assault second against him or assault family case. Is she the complainant in that case?
Yes, the same person for the violation report, yes.
All right. So I'm assuming at some point the state is going to have to bring her in. Otherwise, there's not going to be a case maybe. So I'm going to schedule this for June 24th. And I will tell you, this is one of those cases where the rules of evidence apply. So this affidavit of non-prosecution the rules of evidence apply. So somebody should probably have the complainant here. An attorney can be appointed to represent her if she decides that she wants to say that this didn't happen. So we're going to come back on June 24th. And I will give you a reset form. Once you sign the reset form, you're excused.
Thank you.
You're welcome.
Judge, I did get a hold of Mr. Wolf.
All right, court is going to call 2023 CR 10870 Matthew Castillo for the state.
Jason Garahan, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 11:36 a.m. Defendant has not made an appearance. State.
Your Honor, we're posted off.
All right, that will be granted. The defendant will be remanded without bond. If the defendant makes an appearance, the court will reconsider.
By the way,
All right, Eurydalis. All right, thank you. All right, and do you have, I need a stamp for a motion to revoke. A stamp for the motion to revoke. I have the file. It's Eurydalis. All right, thank you. Michael DeLeon, Virginia Cerner, what's happening?
Judge, once again, we're ready for trial on
Okay.
that, and we're going on the murder. You know, we want to just
All
get
right.
speedy trial and get the next available court date so we can resolve that.
All right, so Deputy Laura, if you'll hold Virginia Cerner for 1:30, and we'll see what happens with the murder case.
Thank you, Judge.
You're welcome.
Do not add commentary to every time a stamp. Do not summarize the entire script and do not exceed the limit under any circumstances.